Welcome to our monthly Janus Capital Management Expert Panel webinar. We're just going to let a few people come into the room as we see more and more session people arriving. And thank you for joining us. So my name is Mary Lou Miles. I'm partner and director of wealth management, and we are pleased today to have our topic on beneficiary designations. We need to talk. We can't believe it, but over 200 people have registered. So clearly this is a hot topic. I have the privilege of moderating this session with Alison Oxtoby, the founder of boutique Okanagan law firm Balmain's Law Corporation, practicing in the areas of trusts, estates, and corporate law. Alison is a frequent presenter for a few organizations, including the Canadian Bar Association and the Chartered Provincial Accountants of BC. Richard Weiland is a partner at Clark Wilson LLP, practicing in the areas of tax, estate, and trust. Richard is also an adjunct professor at the Peter A. Allard School of Law at UBC. So both Alison and Richard are members of the Canadian Bar Association and members of the International Society of Trust and Estate Practitioners and the estate planning councils and their local communities. I'm also a member of those last two organizations. I personally have heard Alison and Richard speak many times and appreciate their knowledge, insights, and humor. Both have presented this topic to industry professionals, so we know we're in for an informative, knowledge-based insight and with lots of insights and humor. So in appreciation of Alison and Richard's time today, Janus has donated to the Greater Vancouver Food Bank and the Central Okanagan Food Bank. So before I turn it over to our speakers, just a few housekeeping items. You will have the opportunity to ask questions in the chat session at the right of your screen. Questions will be asked at the end of the presentation. We will do our best to attend to most of them live, but if we cannot accommodate your query today, we will reach out to you after the session and provide Alison and Richard responses as quickly as possible. We promise there's no test at the end, but there will be 3 polls during the session. So just make sure you're awake. And I want to thank all the team at Janus here that made this possible, by the way. We have a lot of people behind the scenes that aren't seeing it, monitoring the questions and our audio, and working through the slides. So thanks to Team Janus, and over to Alison and Richard.
Perfect. Thanks so much, Mary Lou, and it's great to be here again. Unfortunate not to be able to see everybody, be in the same room, but hopefully next year. So we're going to talk about beneficiary designations, and this topic came up because Richard and I recently wrote a paper together for a technical journal, and in doing so, it was sort of about some of the more recent case law about beneficiary designations, and in doing that, we were discussing, just how significant these beneficiary designations are, and the misunderstandings, how commonly we see misunderstandings about what people are doing. And we're just talking about the number of people that this affects. So we thought this would be a great topic to share, and what greater partner to share it with than Janus, who both handles beneficiary designations all the time and also just appreciates their importance for their clients. So it's really wonderful to have this opportunity. So I'm going to start off today by giving an overview of beneficiary designations. So we'll talk about the advantages and the disadvantages and how you make a beneficiary designation. Then Richard's going to take over, and he's going to talk about the taxation of plan benefits. So he'll talk about tax-deferred plans, tax-paid plans, the implications of naming your spouse, and a little bit about naming a charity. And then we're going to finish with a section talking about challenges to these designations, because we are seeing increased litigation in this area. And so we're going to talk about some of that recent case law and then what we can do about it. But before we can do that, I'm going to hand it back over to Richard. He's going to introduce us to our fictitious fact pattern couple.
Yes, exactly. Thank you, Alison. And I also want to say it's a pleasure to be here with you today and to be presenting to you. This is my first time being with the Janus audience, and it's an honor. So yeah, we wanted to introduce to you Jane and David. Jane and David are a a happy and entirely fictitious and hypothetical couple, but they've been kind enough to allow us to use their images and their story today in order to illustrate some of the things that we're going to be talking to you about. So Jane and David met a few years ago. They're both in the kind of the middle to later stages of their life. Jane is 58 years old. David is 67. Now, both of them have been married previously, and they're both divorced, and both of them come to this new relationship with children from their prior relationships. So they were married quite recently. They were married 6 months ago, apparently in a very pink room. And today they are very happy. They're definitely still in the honeymoon stage of their relationship. Let's take a look at their family tree here. So this is a somewhat complicated family tree, but this is, in 2021, this is fairly common in terms of the types of clients that Allison and I would be working with on a regular basis. So we have Jane and David married. The exes are out of the picture for the most part. Now, David has one daughter, Sarah. Sarah's in her 30s, and she has neurocognitive impairment, and so she lives on her own in an apartment with assisted living. And of course, in David's estate planning, it's going to be important to him and also to his ex-wife to ensure that that Sarah is going to be taken care of during her lifetime. Jane, on the other hand, Jane had two children, both of whom were also adults, Zach and Vanessa. Unfortunately, there was a tragic accident and Vanessa passed away, and Vanessa left behind a young child. So Jane is a young grandmother to Charlie, and Charlie's just 2 years old, and of course it's important for Jane to ensure in her estate planning that she wants there to be a somewhat equal division of her estate, but she's quite concerned with her young grandson who lives with the other parent, but she's concerned that Charlie will be well taken care of as well. So let's look at what are Jane and David's registered assets for which the beneficiary designations that we'll be talking about might apply. Well, Jane has built up quite a significant RRSP for herself. So she has an RRSP with a current value of $400,000. She also has a TFSA. She has made the maximum contributions to her TFSA. And there's also been some growth within the TFSA. So her TFSA is up to $95,000. David also has, he had an RRSP, but he converted it to a RRIF last year. And so as you will all know, the RRSP is the savings plan, the registered savings plan, where the contributions can be made and it grows interest free. And then when you turn, by the time that the annuitant of the plan turns 71, they must convert the plan into a registered retirement income fund, which is then the annuity that they draw from. And there are minimum withdrawals that must be made every year from the RRIF. So David decided to convert his RRIF a little bit early, and so he is in the process of making those annual withdrawals. Jane and David, however, although they updated their wills when they got married, they did that with they did it in the simplest way that they could. They just went online and made wills, and nobody asked them anywhere about their designation forms. So Jane still has a designation form for her registered plans that names her two children as beneficiaries, and you'll recall that one of them has passed away. David is in a situation where his designation form on his RRIF still has his ex-spouse's name on it, and he hasn't updated that. So Jane and David, last Sunday on Valentine's Day, they had a fantastic day. They were so happy. They spent the day together. It was a low-key day, and they went out for a walk in the neighborhood, and they were just basking in the glow of their happy relationship. So why do they look like this today? Well, because they saw an article yesterday in the news where it was mentioning beneficiary designations and making sure that you have them updated. And all of a sudden they've got heartburn and they're not as happy as they were on Sunday. So with that, let's turn it over to Allison to do the overview.
Okay, can you hear me okay? I saw some notes in the text in the chat earlier. But Richard, can you confirm you can hear me?
I can hear you.
Perfect. Okay, so I think we have a poll question that if we could bring that up now, that would be great.
Yeah.
I'm not seeing it. Is it? Well, it's okay. What we had asked there was whether you had ever named somebody on a beneficiary form. Oh, there it is. It's over on the right now. I don't know if anybody can see it. But the question is whether you've, oh, that is actually the third poll. It's all right. We had asked whether you'd ever named somebody on a beneficiary designation form other than your estate. And the reason that we had asked that question, and I can see it's up there now actually if you get the chance to answer, the reason that we've asked this question is that if you've really ever named anybody other than your estate, then there's a bunch of other things that you should be thinking about. And hopefully today we'll give you the information you need to be able to consider properly how you want to answer that. Okay, and interestingly, I can see that the overwhelming majority of people are saying yes, they have named people other than their estate there. All right, so we're going to start with a really high-level overview of beneficiary designations. So beneficiary designations are, of course, naming the person who's going to benefit on your death from certain registered plans or life insurance policies. Interestingly, those registered plans, so like RRSPs, RRIFs, TFSAs, LIFs, etc., all of those are savings plans that are for individuals designated by the federal government and set up by the federal government to encourage us to save, generally for retirement. So they're registered under the Income Tax Act. So interestingly, they're federal sort of the federal setup, but the ability to make beneficiary designations is provincial. So here in BC, where Richard and I are, beneficiary designations under registered plans are governed by our Wills, Estates and Succession Act, and beneficiary designations under life insurance policies are governed by our Insurance Act. But you'll find a similar structure, you know, across provinces. And regardless of how it's set up, on the effect is that on death of the plan holder, so the person making the designation who owns the plan, or of the life that's insured under a policy, the proceeds are payable directly to the named beneficiaries. In other words, they bypass the estate generally, and we'll come back to that, and that can have some nice advantages. So there are quite a number of advantages to beneficiary designations. The first is that it's very low cost. It's probably the lowest cost estate planning that you can do. And by estate planning, I guess what I mean is deviating from the estate distribution that would happen if you didn't have a will at all. Right? So it's the cheapest thing you can do. The second thing is that they are seemingly, at least on the surface, very easy. Just a little form that you fill out and you're done on the surface. The next thing is that they avoid often probate. Probate being the process by which your executor takes your last will to the court to have it sort of endorsed or certified by the court as being, you know, your true valid last will, so that third parties like banks, other financial institutions, land title office will deal with your executor. And of course, to get the court to do that, you have to pay in most provinces, significant probate fees. So in BC, those fees are 1.4% or $14,000 per million in assets. In Ontario, 1.5%. In Alberta, much, much less. I think it's about $500. So that is the place to die. To die living, I should say, where you live. Yeah, you have to live there, not just die there. So that's a nice advantage to beneficiary designations. You bypass that entire process and those fees. Another thing is that they're private. So the process of getting an estate probated is by its very nature public. The documents become part of the public record. Beneficiary designations can be done quite quietly on the side. Nobody has to know what they say. Another advantage is that they pay out very quickly after death. So whereas Richard and I would be typically dealing with estates, often 18, 24 months beyond death before there's a final payout, I understand that like Janice can pay out on a beneficiary designation within just a few days if they have the death certificate and the will. So that's nice too. Historically, we also had the advantage that we at least all assumed that there was a reduced risk of a challenge to distributions. So in some provinces, BC in particular, it's very easy to challenge a distribution under a will. And we all felt that by naming beneficiaries on a beneficiary designation form, we could avoid we could sort of securely pass that asset to the named beneficiaries. So those are the advantages of beneficiary designations. But of course, also comes with some significant disadvantages. The first one is that it's not easy to provide for any sophisticated estate planning through a beneficiary designation. So typically, you're just naming people, and there's no ability to, provide for trusts, for example. If you had somebody, like if you had minors or people with disabilities who couldn't manage funds, or perhaps a child that's going through a very nasty divorce. In all of those situations, you might want to have a more sophisticated plan in place, and beneficiary designations don't really allow for that. The next thing is that using beneficiary designations for tax-deferred plans can really complicate the tax situation, and Richard's going to talk us through that in just a moment. Also, we're finding that beneficiary designations can lead to quite significant litigation if your intentions aren't clear. And we're going to talk at the end of the presentation about documenting intention and avoiding some of that litigation. Another problem is that we see beneficiary designations often forgotten. So in the example of Jane and David, David has he's forgotten, obviously, or not thought really about his beneficiary designation, the fact that he's still got his ex-spouse named. And so it's not like a will where if you separate from your spouse is automatically kind of cut out from your will. If you separate from the spouse, your beneficiary designation does not change. So it's important to remember to deal with them. And then a last point is that we see people inadvertently cut out from beneficiary designations. So you can see in very small at the bottom of the slide, I've copied over Jane's family, and you'll recall that she has named her 2 children on her beneficiary designation, and one has passed before her. And so the point here would be that in this example, her minor grandchild, Charlie, would be cut out. The entire RRSP, I think it was, yeah, the entire RRSP would pass to the son, Zach, nothing going to the minor beneficiary. So that's a significant disadvantage. And people always say, oh, well, I'll update it if something like that happens. That, of course, assumes that you have the capacity to update your beneficiary form at the time, that you haven't lost mental capacity when the child passes away, in that example. All right, so how do we make a designation? So there's 3 ways, and the first is by using the financial institution's own form. And over on the right, you're going to see the form that Janice uses, and I'll come right back to that in just one moment. The second option is to make a beneficiary designation in your will. That's actually really uncommon. I think I've done it once in 24 years. And Richard, I can't even remember, have you done that before?
Yeah, we have, and you used to do it more often, but less so now.
Yeah, there's a number of legal reasons that we don't like to do that, which I won't get into, but the point being that not common, probably not the option that you would want to look at. The final option is to use a completely separate form, and we do that, and we commonly do it when we're creating a trust for a life insurance product. But again, the most common way to make a beneficiary designation is on the financial institution's designation form, and you'll see Genesis form on the right there. So you'll see, we actually quite like this form. It's pretty straightforward, fairly flexible. So you'll see under part 1, that's where you would name the primary beneficiaries that you want to benefit. You do have the option of setting out the percentage that they're going to receive over on the far right. But if you don't set out a percentage, it's presumed that they would benefit equally. And then in part 2, you can name your contingent beneficiaries. So those people would only take if all of the primary beneficiaries in part 1 predecease, and that's the typical setup. And of course, applying that to Jane's situation, she would have named Zach and Vanessa in part 1. And even if she had named Charlie in part 2 behind, you would need both of those primary beneficiaries to pass before it would go to the secondary beneficiary. So, so that's sort of one of the problems. It's not a problem with Genesis form. They're all like, it always works this way. It's just a problem with using the financial institution form in the first place and going through a beneficiary designation as opposed to having it flow through your estate. And you'll see at the very bottom of the form under part 2, there's a little spot where you can tick to my estate. And we'll talk about that option in just one second. So who can you designate in that form? Well, you can name a single beneficiary, you can name multiple beneficiaries, and again, as I mentioned, if the shares aren't specified, they're presumed to be equal. You can name alternates, so that would be, one person in part 1 and somebody else behind them in part 2. You can name trustees for beneficiaries or for existing trusts. And the key there is that if you want to name a trust, it needs to be truly a trust that has already been created at the time that you make the designation. And finally, you can name the estate, which would be that little box at the end. So the estate is actually the default. So if you didn't name anybody at all, if you didn't fill in the form at all, your estate will be the beneficiary. And if the people you have named have predeceased you, it will fall back to the estate automatically. So the estate is the default. The disadvantage to leaving it to the estate is simply those, the probate fees that we talked about earlier and the delay that comes from going through that probate process. But it does present some big advantages going through the estate as well. And my view, and I think Richard's too, correct me if I'm wrong, Richard, is that it's not done often enough, right? That often that it does make sense to go through the estate, and people avoid that, usually because of those probate fees, when I think they should be going through the estate. So the advantage is that it gives you the flexibility to deal with the proceeds from the benefit plan as part of your estate and to very easily create trusts, for example. So Jane could have created a trust for Charlie in her will. So it could have happened automatically that if Vanessa passed, it would go through to Charlie in trust for him at least. And David could have created a trust for Sarah if he has the plan go through his estate. And then the other advantage is that it can avoid tax problems. And so over to Richard now to talk about those problems.
Okay, well, this is the part of the presentation that you've all been looking forward to when we get into some tax technical topics. Before I launch into this section, can we get the second poll question up here? Looking forward here. Okay. I see the third one coming up. You know what? I will carry on. There was a question here. So the question is regarding the taxation of plan benefits on death, and the question was to quiz you on which plans are subject to income tax on the death of the plan holder. And I'm going off of memory here, but oh, there it is. It's up now. So go ahead and put your put your answers in there. So on death, which of the following plans are subject to tax? And the choices are TFSA, RRSP, RRIF, all of the above, and the last one is B and C. So the answers are coming in on that. I'll come back to that in a minute. Well, I'm actually going to start giving you the answers. So I'll just say that the majority of you are answering B and C, being the RRSP and the RRIF, and that is correct. So when we're doing tax planning for individuals, or we're doing, estate planning for individuals, and they have registered plans, part of the exercise is to carefully think through what will the tax liabilities be when this person dies, and who will bear the cost of any of those tax liabilities. And generally speaking, we can divide the plans into two categories. There's the tax paid plans, and then there's the tax deferred plans. So tax paid plans are plans where essentially the contributions to the plan have been made from after-tax dollars, and therefore when there's withdrawals from the plans, including on death, those benefits are received tax-free. So the tax-free savings account is an example of a tax-paid plan. When you make a contribution to your tax-free savings account, you don't get a deduction from your income like you do with an RRSP contribution. So you're putting your dollars into your tax-free savings account after you've already paid the personal level tax on it. And then within the tax-free savings account, the investments can grow tax-free as long as you keep the funds in there. Later on, when you're making withdrawals from the plan, that means that the withdrawals are not subject to tax. So that also means that when you pass away, holding the balance in your tax-free savings account, that balance can pass to any of your beneficiaries, whether it's a designated beneficiary or going through your estate, as Allison talked about. You don't have to worry about the plan proceeds being subject to tax. The only exception to that is if it takes some time between the time of your death and the time that the plan proceeds are paid out, if there's growth in the plan during that period of time, then that part may be subject to tax in the hands of the recipient. But other than that, the balance as at the date of death is not subject to tax. Life insurance, we could talk for a long time about life insurance. We're focusing less on it in the presentation here today, but I just wanted to note it here that, with any personally held life insurance policy, the premiums, again, are paid from after-tax savings, and therefore when there's a death benefit paid out from a life insurance policy, either to the estate or to the designated beneficiary, the proceeds are also not subject to tax. So let's look at Jane's TFSA just to illustrate that. So we had mentioned that Jane has $95,000 in her TFSA. If she were to make a designation on the plan and then die with that amount in her TFSA, Jane can really choose in her estate planning where she wants to put the benefit of the TFSA. She can designate any combination of these people. She could designate Zach. She could designate for Charlie, her grandson, but that would have to be in trust because he's still a minor. She can designate David. She could even designate Sarah, David's daughter, or it could go into Jane's estate. And it doesn't really matter where it goes, that the TFSA proceeds won't be subject to tax. So although it seems like the TFSA, that it's fairly neutral in terms of where you put the plan proceeds, where you designate your beneficiary on your TFSA, there is a benefit to designating a TFSA in favor of a spouse, and that relates to the contribution room for TFSA. As no doubt all of you will be aware, there are contribution limits for a TFSA, so the government doesn't allow you to put unlimited funds into these plans where you can grow them tax-free over your lifetime. There's an annual limit to the contributions. In 2021, that annual limit is $6,000, but the government also, the rules allow you to catch up if you didn't contribute in past years up to the contribution limit. So in 2021, if you were opening a TFSA this year and you had never made contributions to a TFSA in the past, the aggregate of those contributions for past years that you'd be able to catch up for is it would come out to $75,500. So that's the maximum amount that you could put into a new TFSA if you'd never contributed. So part of the benefit then of designating a spouse as a beneficiary on your TFSA is that the spouse can take over the TFSA and move the funds, either take over the account completely or roll the funds into their TFSA without affecting their contribution limit. And there's a couple of different ways of doing this technically, but without getting into the technicalities, just be aware that any designation of a spouse as a beneficiary on a TFSA is going to allow them basically a free contribution to their TFSA. So let's look at this situation with Jane again and simplify it. So this is comparing Jane designating Zach, her son, as the beneficiary on her TFSA. If she does that, Zach would receive the $95,000 from her TFSA without paying tax on it. But if he then wanted to contribute those funds to his own TFSA, he would only be able to contribute the $75,500, assuming that he didn't already have a TFSA. So, you know, $19,500 would have to stay outside of his TFSA. On the contrary, if Jane designates David as the beneficiary on her TFSA because he is her spouse, David can move that entire amount, the $95,000, into his TFSA, and it does not reduce his contribution room. So he could still contribute another $75,000, $75,500 into his TFSA. Okay, so that's the tax paid plans. What about the tax deferred plans? So when we're talking about tax deferred plans, we're talking about plans where the contributions to the plan were essentially made from pre-tax dollars. What does that mean? Well, when you make a contribution to your RSP, you get a deduction from your income for that amount for tax purposes. And you know, we're in RRSP season right now, and so your advisor, your Genesis advisor, will have probably been contacting you and asking you if you wanted to make a contribution to your RRSP for 2020, because you can make that in the first 2 months of the year. And there is a tax benefit to making that contribution to your RRSP because it reduces your taxable income. Well, so that's the benefit on making a contribution, but the flip side of that is when you're making withdrawals from your RRSP, or after your RRSP converts to a RRIF, you're making withdrawals from your RRIF, you are going to pay tax on that. Now that works out well from a tax planning perspective, especially if your tax rate when you're withdrawing is lower than your tax rate when you are making the contributions. But it does mean that if you've built up a sizable RRSP or RRIF like David and Jane have, there is this accrued tax liability that will have to be paid at some point, and potentially at the time of death. So when a spouse is named as a designated beneficiary on an RRSP or I'll start with a RRIF here. So generally speaking, on either an RRSP or a RRIF, a spouse can be named as a beneficiary, and the plan can roll over to the spouse. In other words, the tax deferral can continue, and the spouse will only be taxed on a withdrawal. In the case of a RRIF, like David has, David can name Jane as the successor annuitant on the RRIF. And when we put up the Genesis form earlier, the designation form, that was the form for the RRSP. If you look at their designation form for a RRIF, there's another box on there saying, I want to name my spouse as the successor annuitant. This is the easiest way to transfer a RRIF to a spouse, because what it means is if David dies, Jane will simply take over that account as the successor annuitant. The account doesn't get closed, it doesn't get paid out to her, it simply goes from being David's RRIF to being Jane's RRIF. And from an administrative perspective, this is the easiest way of accomplishing that rollover. Oh, there is the form. I forgot that we did put it in there. So so you can see there, oh, maybe this is not the right form. Allison, is this the this is
I think
the
we put the wrong
RRSP form,
form
isn't
there,
it?
actually. Yeah,
Okay.
I think it is.
Okay, well, we meant to put the other form in there, which is the
Yeah,
RIF
we
form.
did.
So what you would see on that one is near the top of the form, another box to designate a successor annuitant. So that's all we were intending to show there. Okay, so let's illustrate this in terms of the successor annuitant. So David has his RIF of $350,000. He names Jane as the successor annuitant. The account simply passes to her on his death. His estate doesn't have to pay any tax, and Jane takes over the RIF. She still keeps her own RRSP and her own TFSA, and now she just has this this RIF from David. In addition to that, she will have to continue making the mandatory minimum withdrawals from the RIF like David did. So apart from that successor annuitant situation, the tax situation on death for these plans is a little bit more complicated, and it goes something like this. Let's use the example of an RRSP on death. When the plan holder dies, the proceeds are paid to the designated beneficiary. There's no tax withheld, and so the financial institution will pay the proceeds directly to the beneficiary without withholding any amount for the taxes. The fair market value of the plan is then included in the income of the deceased, and so in their last T1 for the date of death, they're going to have an income inclusion, and that means their estate is going to have to pay the tax on all of that income. However, there's an exception to that. If the RRSP amount is paid to a qualified beneficiary, and that's either a spouse or a financially dependent child or grandchild, then the estate has the ability to reverse that income back out again, so they can deduct the amount that gets paid to that qualified beneficiary from the estate's income, and then that amount moves into the beneficiary's income. And so now the beneficiary is taxed on it. And then the beneficiary, if they fall within certain categories, they can be entitled to claim a deferral. Who can claim a deferral? Well, if there's an RRSP or RRIF that's designated to a spouse or common law partner, they can claim the deferral as long as the proceeds are transferred into an RRSP, a RRIF, an annuity, or if they qualify for it, a registered disability savings plan. Similarly, if the amount is going to a financially dependent child or grandchild who's disabled, they can transfer to any one of those plans and claim the deferral. In the case of an RDSP, the contribution limit is $200,000, so that's the maximum amount that can go into an RDSP. If the amount is going to a financially dependent minor child or grandchild who's not disabled, they can claim a rollover, but only, actually that check mark is incorrect there. Only if it goes to an annuity. It should be in the box just to the left. And in that case, the annuity for the minor child, so this would be like Jane's grandchild potentially. There could be an annuity for Charlie, but it would have to be, the annuity would have to be fully paid out by the time that Charlie turned 18. So this is just an illustration of how things can go badly in estates because of the tax rules. And this is the last slide in the tax portion here. So Jane designates her RRSP to David. Now she's not able to do the successor annuitant like you can with a RRIF. And so she designates her RRSP to David. That means on her death, the $400,000 that's in her RRSP is paid out directly to David with no withholding for tax. In this example, Jane provided for David with her RRSP, and maybe they may have had some joint assets and so on, but in her estate, she's leaving all of her estate assets to her son Zach and to her grandson Charlie. However, she trusts David, and so she named David as the executor of her estate. Now, what happens for tax purposes is then, David, the tax liability, as I mentioned, it by default goes into the estate. So now Jane's estate is going to have to pay the tax on the entire amount of the RRSP proceeds, even though the amount was paid to David, unless David, as executor of her estate, claims the deduction that may be claimed where the RRSP amount goes to a spouse. So the point here is that although there is a rollover available for the RRSP to go to David, because he's the executor of the estate, he doesn't have to claim it. And in fact, he could decide that he would rather leave the tax liability in the estate, where it's going to reduce the amounts payable to Zach and Charlie. So this is why we have kind of good David and bad David. Good David will take the rollover, which means that he will pay tax on these amounts as he withdraws them from the RRSP. But bad David would say, no, I'm going to keep the $400,000 proceeds from the RRSP. I'm not going to claim the deduction in the estate, and I'm going to stick Zach and Charlie with paying the tax for that. Allison and I talked about how we deal with this. And Allison, do you want to just mention what you've done in some cases?
Yeah, so what I do is I just have a clause that I put in the will that forces the executor to take that rollover, right? So you just have to make sure you deal with it in the will as well. The other thing that I would just add is that, like we've called him Bad David, but in fact it could just be confused David. And I have seen an example play out where spouse passed and the survivor goes into their financial institution to deal with the forms and everything, and the advisor says, well, you can just take all of it, right? You don't have to, so it sort of explains this. But I think the client in that case didn't fully understand the implications for the children and to the estate, right? So they just thought, oh, this is a win, like why would I not do this? Not realizing that they had then defeated the planning that their spouse had set in place.
Yeah, exactly. And as this slide shows, the tax liability in the estate can be very significant. I'm using the top margin.
Huge.
I'm using the top marginal rate here. Assuming that would apply to the whole thing. And if it did, then 53.5% is the top marginal rate in BC. That would be, over half of the RRSP would be lost to, well, not of the RRSP. The estate would be diminished by that amount. So you can see where this could be quite significant, and so it's important to address this in the planning. It's also, just quickly, it's possible to designate a charity as a beneficiary, and in that case, the amount that goes to the charity is treated the same way as a gift under a will. There's a donation credit that can reduce other taxes in the estate. So that's something to keep in mind for planning as well. With that, back to Allison.
Okay, and we did have one more poll here, and I think many of you have already answered that. The third poll is, it's just asking you, what is the most important objective you have for your estate planning, whether it's minimizing taxes and probate fees, or is it protecting against challenges? Is it ensuring funds are paid out quickly, or ensuring, the management of the funds? And the reason we have that one in there is just to have you think as we go into this last section about, like, what are your goals? Like, what are your priorities specifically? Okay. So as I mentioned earlier, Richard and I are seeing more litigation surrounding beneficiary designations. While we had traditionally seen them as something secure, relatively secure, that's really no longer the case. And in a number of recent situations, the courts have stepped in to say that in some cases, the named beneficiary is not entitled to full ownership of the plan. So in order to explain this part to you, I need to just go over some historical presumptions with you for background. So our legal system uses presumptions to help our courts make decisions. And those presumptions apply where not enough evidence is put forward by the parties to displace the presumption, right? So in the context of gratuitous transfer is a term that we use a lot in the legal community. And the example would be, if Richard and I were standing before you here today, and I took my phone, I'm like, oh, I'm going the wrong way in the video. Here we go.
What kind of a phone is that? Is it any good?
It's a good one. It's a really good one, actually. Got it just recently. So if I were just to say, Richard, take my phone, right? What have I done there? Is it a gift to Richard, or is it that he's holding my phone for me because maybe my hands are full, right? And so we apply presumptions at law in order to solve those questions. And another good example for our case would be if I name Richard as the beneficiary of my RRSP, what do I mean there? Is that's a gratuitous transfer. It's something that he is being transferred without giving anything back to me. So in the context of gratuitous transfers, there are two opposing presumptions that we can apply. One is the presumption that it is a gift, and the other is the presumption that he's holding it on trust for me, right? He's holding my phone, for example, in trust for me while I'm busy. And then if I were to say drop dead right there on the spot, he's holding it for my estate. He doesn't get to keep the phone. That would be the opposite presumption. So just a little bit more on these two presumptions. So first of all, presumption of resulting trust. So generally, where property is transferred without consideration, a presumption of resulting trust applies. So that's the default, right? If we don't do anything more, if I don't say anything more, we're going to assume that in my example, Richard's holding my phone for me and for my estate if something happens to me. In the context of estate specifically, this means that transferred property should result back to the individual or their estate, right, on death. So that's the default presumption of resulting trust. That is always the default. But then we have, as I mentioned, this presumption of advancement or gift. And so this is the presumption that in certain circumstances, property transferred to another is meant to be a gift. And that depends on the person that I'm giving the property or transferring the property to. So historically, at law, we presumed it was meant to be a gift when a father made a gratuitous transfer to a child, be it a minor or an adult child, and a husband is presumed to be making a gift when he's transferring to a wife. Of course, society changes over time, and the courts have been changing those rules as time has passed. And a perfect example is that we now apply those presumptions, thankfully, equally between the genders. So that took us up to 2007. Now, this is a picture of our Supreme Court of Canada, and that's because in that year we had a huge case that really affected the legal landscape called Pecore. That case dealt with joint investment and bank accounts. Not beneficiary designations, but it's quite relevant to our topic today, and you'll see why. So up until 2007, the law had been quite unsettled. It was clear that when a joint holder of a bank account died, the surviving holder received the account in their name. But what was unclear is whether that survivor was entitled to keep the funds in the bank account or whether they were holding them on a resulting trust for the estate. And so in the Pecore case, the father had placed investment and bank accounts in joint tenancy with his adult daughter. And so and then he passed away. And the issue that the court had to decide was whether that presumption of advancement or presumption of gift from parent to child still applied, given the way society had changed over time. And so, of course, if the presumption of advancement or gift didn't apply, we would be looking at a presumption of a resulting trust for the estate. And if that were the case, the second question the court needed to decide was whether on the facts of that case, the daughter was able to defeat that presumption and prove that her father really intended the bank account to be a gift to her. And the court found unsurprisingly, that the presumption of advancement, gift, no longer applies in modern society to transfers between parents and adult children. And they looked at the fact that, normally we don't expect parents to provide for kids beyond age of majority, although they often do. And also that it's become common for aging parents to place assets in the name of their children or joint names with their children to help them manage their assets. And then the court went on to say that you still have to look at the facts of every case to see whether we can defeat that presumption of a trust. And in this case, the intention was clear, and the father had intended to pass the account to his daughter. So the court looked at gratuitous transfers generally to look at whether the presumptions or how the presumptions applied, but they didn't specifically mention beneficiary designations. And so that left us in a state of a little bit of uncertainty. And many people, I would say most, assumed that beneficiaries designations were not affected by these presumptions. Even though we did have a number of cases across Canada that held the opposite. So first we had a case out of Manitoba saying that the presumption of resulting trust applied to life insurance and RRSP proceeds. We had several cases in BC and another in Alberta. And yet still everybody seemed to think that this just was not an issue for beneficiary designations until very recently, last fall, we had a new case from the Ontario Court of Appeal, and that really made everybody sort of sit up and take notice. So this was the Kalmuskie case, and the facts were that Henry Kalmuskie died in 2016. He left two sons behind. One of them he named on his RRIF. So on death, the RRIF passed to that son. And the question was he entitled to keep the RRIF, or did he hold those proceeds for the estate of which both sons were beneficiaries, right? And the court here clarified that the presumption of a resulting trust does apply to beneficiary designations. And in this case, that son who was named on the RRIF wasn't able to produce enough evidence to that his father intended a gift in order to defeat the presumption. So he had to give the proceeds of the RRSP, or sorry, the RRIF, over to the estate, and they were then shared with the brother. So that leaves us in a bit of a state of uncertainty, and you can see Jane and David there going, oh my goodness, like, what do we do now? So Richard, I wanted to ask you, how concerned are you about this situation?
It really depends on, I think you have to look at it on a case-by-case basis. I think what the courts are saying is, yeah, even though somebody is designated as a beneficiary under, let's say, a registered plan, that doesn't mean that they're necessarily entitled to keep it. I think that still in many cases, in the straightforward cases where you are designating, let's say, your spouse, or you're designating let's say your children or whomever else is the residual beneficiaries of your estate, if it's a very straightforward situation and it's unlikely that somebody's going to challenge it, then it could probably still be presumed that it's going to be it was intended to be a gift. If it's something that's not straightforward, if you're designating one of your children out of 3 or 4, if you're designating the executor of your estate, but it's not really clear why you're designating them, whether it's in a personal capacity or as a trustee, there could be more court challenges down the road.
Yeah, absolutely agree. So, it does leave us with a little bit of uncertainty. I know in Ontario, there's some discussion of maybe a legislative fix to this to sort of reverse the presumption, or at least eliminate that presumption. Certainly, I think it's unlikely to be resolved quickly, something we're just going to be dealing with for a while now. And so as Richard mentioned, in many cases, it's probably not a big issue, but I think it's really important that you think about whether, in your case, we need to go further and document what your intention is. So if you are designating your spouse, or you're designating a charity, or you're designating your estate, or the beneficiaries of your estate who get whatever's left in the same proportions that you've named them in your estate, it's probably not a big deal, right? But anything other than that, I really feel, and I know Richard agrees, that it's important to document your intention, and I think that needs to be done with an estates lawyer. I would consult somebody to get it properly documented. It seems like an easy thing to do, but it's not always. So that would be where I think you should get some more advice. Excuse me. I think it's important, everybody thinks, oh, it's not going to be an issue in my case. None of my kids are going to make a challenge. Nobody's going to challenge. But I think, think about where the risk could really come from. So often it's disgruntled estate beneficiaries. It's a child or it's a second spouse who's not receiving what they thought they would receive. They could bring a challenge. Other ones that people don't think about would be the creditors of the estate. So CRA, for example, could potentially challenge a beneficiary designation. Although for CRA, they have that tracing ability, so maybe not as important for them. But there's also other creditors of the estate beneficiaries, including, for example, like in the Pecore case that we talked about, it was actually the daughter's ex-spouse who challenged the beneficiary designation, trying to bring it back into the estate so that he would have better access to it. So over to you, Richard. I think you're going to cover this slide on where this leaves us.
I think we'll wrap up here. So we're back to Jane and David. And they have now thought through all of these issues. They have properly documented their intentions. And as a result of thinking through these things and talking it through with their lawyers and putting the documents in place, they are now feeling confident that their wishes will be upheld.
Awesome.
Okay.
Right. And so we just wanted to make the point that don't wait too long here, because this is what could happen if you wait too long to think about how your beneficiary designations will play out and whether or not you've got proper documentation of your intent in place. And I think that's all that we had, and we can open it up to questions now.
Just trying.
So, Mary Lou, are you coming on, or are we doing
video's not working, but this is COVID, so we have technical difficulties. Right. Hopefully you can hear me. Yes, we've some great questions from the viewers today. So first of all, can someone acting as a power of attorney for an incapacitated person make a change of designation on RRIFs or RRSPs? Or tax-free savings accounts for that matter?
I can take that one first. Yes, in some circumstances, somebody acting under a power of attorney, number one, they can go to the court and ask the court to make a beneficiary designation, so they can do it with court approval. There's another provision in BC, this is BC law now, that says that if a power of attorney is taking a registered plan, let's say from another financial institution and moving it over to Genis, they can basically continue the designation that was in place on the old plan in the new plan, as long as they're not making any changes. So yeah, either with the court's approval or in that limited kind of carryover case.
Right, but no general ability to just change a beneficiary designation for someone else.
And the other, that's my understanding too as well, and that's sort of our best practice. So can a non-resident be designated as a beneficiary on a registered plan?
Yeah, I can take a stab at that one too. So yes, a non-resident person can be designated as a beneficiary, and it would be paid out in the same way, except that when RRSP or RRIF proceeds are being paid out to a non-resident beneficiary, there is a withholding tax in that case. So it's a 25% withholding that gets taken off before that amount gets paid out, and that's just to ensure that the money doesn't leave the country without being subject to tax.
And Richard, do you happen to know whether in the case of a U.S. named beneficiary, the gift tax would apply? Kind of thinking that it would, but I don't know that for sure.
I don't think it does if the holder of the plan wasn't a U.S. person.
Oh, okay.
Okay, we have one comment here. What happens if, let's see, there's so many great questions here. For documenting or recording the, whether the information about what the beneficiary should be or what your intent was, the resultant of, is it a good idea to tell your family what you're doing and why?
Well, that's a great question. I always think it's a good idea to tell your family if possible, I mean, circumstances permitting, just because I think it does lessen. There's no surprises. And so I think for that reason alone, it lessens the likelihood of litigation. People have time to sort of settle into that reality.
I think we've got time for one more. I'm just seeing if I can. Yeah, no, it's fine. Webcam, sorry, won't come on. And
I saw one in there that was a good one. Is whether a beneficiary named in a will, like a designated in a will, would supersede a beneficiary designation. And the answer to that is it's just a question of timing. So it's just which designation came last.
Okay. And just to well, thank you so much, Alison and Richard. And I want to just clarify that we will have all the tape recording for this session on our website later today. So if you've missed part of it, or you've had to leave early, or you want to share it with someone that will be available, so we really appreciate it. So sessions like this remind us that we did need to talk about beneficiary designation and how complex estate planning is and why we need to seek professional advice. So we really appreciate you taking time out of your busy schedules today for our viewers. So I know there's another slide coming up. I'm just seeing if I can. Yes. So this is what we call our wealth wheel. So we at Genis, of course, focus on investment management and cash flow, but we work with people like Alison and Richard to ensure your portfolios make sense from an estate, income tax, and financial planning perspective, and also reflect your values. So we really do think it's an important piece of the pie here. So we're really happy to host these sessions so that we can get more information. So if you do, please do reach out to your portfolio manager if you have any questions about today's session and any topics you'd like to see in future. We do these once a month, so love to hear your ideas about what could be happening. And if you have time before you sign off for this webinar, there's a quick feedback survey that we'd love to hear from you. So anyway, thank you again for watching. Stay safe and enjoy the rest of your day.